So good morning again, and I'm very happy and glad to introduce this conference about the death of law with the interrogation mark. So it's a question we are not sure about the death of law, but there is a possibility that there might be the death of law. So this is our conference issue, and this refers to the incredible development and evolution of the so-called artificial intelligence in our lives, and especially its use in the law. We use this title, "The Death of Law," interrogation mark, taking it from one article by Professor William Lucy. William Lucy is sitting there. He has written a very interesting article about the death of law. This has been in English, then translated into Italian. But William Lucy has been inspired by the seminal work done by this gentleman, Professor Brownsword. This is one of his books, Law 3.0. And the idea is that we have now experiencing a third stage of legal evolution. The first stage is the traditional one, where law is driven by rules and the standard of coherence. When we apply rules, we try to apply rules in a coherent way, in a reasonable, coherent way. Then Professor Brownsword claims we had a different stage, so a kind of evolutionary stage. And this would be the regulatory stage, where rules are used more as means to achieve specific ends. And this would be Law 2.0. This evolution between this kind of, the first one, formalist, we could say, species of law, and the second one, more, let's say, instrumentalist, has been a matter of discussion already in the 70s, or I would say even the 60s. And one of the leading scholars dealing with this transformation was Luhmann. You might remember, perhaps, if you had any occasion to read Niklas Luhmann, a German sociologist, that Luhmann believes that the law from a conditional, so-called conditional program, where law is made through rules, by rules, consists of rules, and the rules is a conditional judgment. If A, then B, and then B is a command, an imperative, whatever, we have a different, and this, if A, then B is normative, then we have a different approach to law, which was connected with the emergence of the welfare state, the enlargement of state public policy interventions, and that was called purposive program, from the conditional program to the purposive program, so that we go from laws to rules, general rules, to specific measures that are thought to achieve specific, special results. And now this is more or less what Professor Brownsword means when he believes that we have Law 1.0, so in Luhmann's terminology, conditional program, Law 2.0 in Luhmann's terminology, purposive program. But then there is a third one. We have a third leap forward. And this third leap forward is done through modifying the environment. So we have no longer rules, but a kind of environmental control. Professor Brownsword will be more specific about it, I hope. I will not indulge into this. And then, especially through the use of algorithms. And algorithms, they are not performed, they are not effective through normative imputations. So they not appeal to be followed or not followed. They cannot be violated. Algorithms are self-executing. In the concept of law, which is the seminal work written by Hebertat in 1961, Professor Brownsword even claims that in the next 2031 there will be finally the death of law, and there will be after 70 years the concept of law of heart would be completely, so to say, useless to understand the law. We'll see. If we have the chance to see it, we are old actually. Well, we'll see. In the concept of law, Hebertat said that law rules are not self-executing. So one characteristic of rules is that they are not self-executing. This is a quotation you find also in Aristotle. Aristotle somewhere says exactly the same phrase. And you find the same, absolutely the same, in the Kritik der reinen Vernunft by Kant. Rules are not self-executing. So rules should be applied through human beings using their intelligence, their prudence, evaluation, adapting the rule to the specific case. Actually, adapting the rule to the specific case is the basic form of Urteilskraft. It is the faculty of judgment, or in the case of Aristotle, of phronesis. The phronesis is, the prudence is the faculty of being able to apply the general concept. A general concept is a rule. The concept is a rule, to a rule for cognition, so to say, not for performances, but nevertheless a rule to the specific case. And only in this way we can apply, we can understand things, and we can know things. The idiot, the stupid, and this is thematized very well by Nikolai Hartmann in one of his seminars. There is a very small book by Nikolai Hartmann, who was a German philosopher, and he published, there is a publication of seminar discussion made at home with students. There is one discussion about stupidity. What is stupidity? The stupidity is exactly the incapacity or the limited capacity of applying rules, of applying the concept, the general concept to the specific case. Well, now this is a lot of meat to cook. I stop here.